Welcome to our VirtuaLaw Legal Analysis series. In today's episode, we will discuss the meaning, application and case sample of Impotentia excusat legem. Let's dive right into it. Impotentia excusat legem is a Latin phrase that translates to impossibility excuses the law in English. This legal principle is also known as the doctrine of impossibility. It refers to a situation where the law may not hold a person or entity responsible for non-performance of a contractual obligation, or for failing to comply with a legal duty if the performance or compliance has become genuinely impossible. Meaning and application. The doctrine of impossibility is a defense that can be invoked when a party's inability to fulfill their obligations arises due to circumstances beyond their control. It operates on the principle that it would be unjust to hold someone liable for an event that was unforeseeable, unforeseen, and genuinely beyond their power to prevent or overcome. There are generally two main types of impossibility that can excuse non-performance. 1. Objective impossibility. This occurs when it is physically or legally impossible to perform the contractual obligation or duty. For example, if the subject matter of a contract is destroyed, or if a law or regulation is enacted that makes the performance illegal, it could be considered objectively impossible to fulfill the contract. 2. Subjective impossibility. This type of impossibility focuses on the specific circumstances of the party involved. It comes into play when a specific individual or entity is unable to fulfill the obligation due to some personal incapacity or unavailability. For instance, if a person becomes incapacitated or dies, making it impossible for them to perform their obligations under a contract. Sample case. Let's illustrate the principle of impotentia excusat legem with an example. Suppose there is a contract between a construction company, contractor A, and a client, client B, for the construction of a new office building. The contract specifies a specific time frame for completion. However, before the project starts, a natural disaster like an earthquake occurs, severely damaging the construction site and surrounding infrastructure. In this case, if the earthquake makes it objectively impossible for contractor A to complete the building within the agreed-upon timeframe, they may be excused from performing the contract as per the doctrine of impossibility. The event was unforeseeable and beyond their control, rendering the performance genuinely impossible. It is essential to note that the application of the doctrine of impossibility may vary depending on the jurisdiction and the specific circumstances of each case. Additionally, some contracts may include provisions for handling such situations, like force majeure clauses, which address unforeseeable events that prevent or delay performance. These clauses may specify the rights and obligations of the parties in cases of impossibility. That's all for this episode. Stay tuned for more legal insights in our future episode. Remember, understanding the law helps us comprehend the intricacies of our legal system. See you next time. Like and subscribe.